Good morning. Can everyone start making their way to their seats, please? Start making your way to your seats. We're about to get started. Senator Lee. Majority Leader Fenberg. Good to see you. Good morning. Thank you, everybody. The joint session will now come to order. Majority Leader Fenberg.
Thank you, Mr. Speaker. Members, I move that the morning roll call of the Senate be made the Senate roll call of the joint session.
Seeing no objection, the morning roll call of the Senate will be made the Senate roll call for the joint session. Madam Majority Leader.
Thank you, Mr. Speaker. Members, I move the morning roll call of the House be made the House roll call of the joint session.
Seeing no objection, the morning roll call of the House will be made the House roll call for the joint session. A quorum is present. As is customary, it is my privilege and honor to present the gavel to the President of the Senate with a request that he preside over the proceedings of the joint session.
Thank you, Mr. Speaker. Will the Joint Escort Committee, composed of Senators Coleman and Gardner and Representatives Gonzalez-Gutierrez, Dougherty, and Lynch, please escort the Chief Justice to the House chambers.
Mr. President, Mr. Speaker, ladies and gentlemen, please rise for the Chief Justice of the State of Colorado, the Honorable Dougherty.
Will the Escort Committee please proceed the Chief Justice to the podium? Members and guests, it is my honor to present to you the Honorable Brian D. Boatwright, Chief Justice of the great state of Colorado.
Please be seated. Thank you. Speaker Garnett, Senate President Garcia, distinguished members of the House of Representatives and the Senate. This past week, I reached out to a long-term employee of the judicial branch, and I asked her how she was doing. She's normally very upbeat and positive. That day, she was very direct. She responded that for the first time in her 20-year career, she was not proud to tell people that she worked for the judicial branch. That broke my heart. But it also steeled my desire for answers. I'm here to tell the legislature, the governor, every member of the branch, and most importantly, the citizens of the state of Colorado and that employee, that we're going to get this right. Where there was wrongdoing, we will address it. Where there was an abuse of power, we will stop it. Where our policies are deficient, we will change them. We want to know the truth. We recognize the branch faces a crisis of confidence in its leadership. We know that investigating and addressing the allegations within the branch will be a difficult process, but we are committed to seeing it through to the end. This will result in a culture change, and we are going to make sure that happens. When I say we, I mean every member of the Supreme Court. While we frequently disagree on the difficult legal issues that come before us, we are united and speak with one voice when we declare our commitment to this cause. When I say we, I also mean our State Court Administrator, Stephen Vasconcelos, who started in that role after the first round of allegations came to light 18 months ago. When I say we, I include the leadership team at the State Court Administrator's Office. When I say we, I also mean the chief judges, court executives, and chief probation officers of the courts across this state. All leadership in the branch is committed to ensuring a safe and healthy work environment. With the flood of news in the past couple of weeks, it's easy to lose sight of the fact that we have so many dedicated public servants in the branch who care deeply for the citizens we serve. I know that every member of the branch wants answers. I know that every member of the branch wants answers and wants to get this right. Everyone at the State Court Administrator's Office, every judicial officer, every clerk, and every probation officer. Even though they may not be proud of me at this time, I want to say here that I'm proud of each and every one of them. In the end, I want them to be proud and say that they work for the judicial branch. We have all heard the claims about the training contract and the document, which have been referred to as a memo, and that's been released. And that's been the subject of much conjecture. I'm not here to comment on any of those claims and conjecture, except to say that the branch takes the allegations of misconduct by judges and staff extremely seriously. The conduct described in the allegations, if accurate, is unacceptable and cannot and will not be tolerated. We need to know if Human Resources investigated any of these allegations, and if they did, what action was taken. And if the investigation didn't occur, we need to know why. We need to know what we need first and foremost is the truth. Therefore, I've requested a full investigation of the circumstances surrounding the contract and an investigation into each and every incident listed in the document. I've asked the Governor, the Attorney General, as well as leaders of both parties in the House and Senate to provide representatives for an independent panel that will draft a request for proposal to first define the scope of the investigation. Per our procurement regulations, and we are going to do this by the book, the request stays open for 30 days. Then the panel will meet again and select the independent counsel or counsels from those who have submitted proposals. That person or firm will then conduct the investigation, and we hope to announce members of the panel shortly. With this procedure, the judicial branch will not have any say in the selection process. We will cooperate with the investigation, and we will publicly release the results. We also hope the investigation will provide some specific recommendation for changes that we can make to ensure a safe and healthy work environment for all members of the branch going forward. All we ask is that the independent counsel conduct a thorough, efficient, and fair investigation. Until the investigation is completed and any recommendations are implemented, I am to be made aware of any new allegations of misconduct and be kept apprised of the progress of any investigation on a weekly basis. I said that each and every justice is committed to reform, and I'd like to tell you briefly who we are. Not just who we are academically or professionally, but who we are as people. Since we do everything in an order of seniority, including where they're seated, I will start with the most senior. First, Justice Monica Marcus. Justice Marcus' roots lie in the San Luis Valley, where the Marcus family has farmed and ranched for several generations. She grew up on the western slope and graduated from Grand Junction High School. After college, she served in the Jesuit Volunteer Corps, working with inner-city youth. Her teaching and community organization experiences in underserved communities inspired her to go to law school. Throughout her career, she has worked tirelessly to promote diversity in the legal profession, and she engages regularly with diverse youth, law students, attorneys, and judges to build an inclusive legal community in Colorado. Second, Justice Will Hood. Justice Hood and his wife Diana moved to Denver more than 30 years ago with a desire to put their law degrees to use for the public good. Will has spent 24 years as a government lawyer or judge. When he was last in private practice, he was the firm's pro bono coordinator. Diana has spent 29 years working in legal aid or running a nonprofit that helps abused children. They are most proud of their 2 adult daughters, one of whom is a legislative aide combating climate change, and one of whom is training to become a wildlife rehabilitation specialist. Third, Justice Richard Gabriel. Justice Gabriel grew up in a working-class family in Brooklyn, New York. He's the first generation in his family to go to college. Because he was able to attend college and law school only with the help of significant financial aid, he's devoted his over 30-year career to paying it forward, mentoring countless students and young lawyers, educating the public about the judiciary through our court's civic education program, and promoting professionalism and civility among the bench and bar. Additionally, you can't introduce Rich without noting that he has played the trumpet professionally for almost 50 years. Fourth, Justice Melissa Hart. Justice Hart grew up in the Park Hill neighborhood here in Denver, where she and her family still live today. She was appointed to the court in 2017. For 18 years before joining the court, she taught at the University of Colorado Law School, where her scholarship, teaching, and public service work were focused on anti-discrimination and access to justice. She has carried those commitments with her to the bench. In 2018, Justice Hart helped launch Legal Entrepreneurs for Justice, an affordable law practice incubator committed to training lawyers who will serve low-income and moderate-income Coloradoans. She has continued to teach at CU and now teaches at DU, where her class this semester focuses on access to justice. Fifth, Justice Carlos Zamor. Justice Zamor was born and raised in El Salvador. When he was 13, political unrest forced him and his parents and his 11 siblings to flee the country. After receiving a death threat, the family packed what they could in their van and they left El Salvador forever. With visas in hand, they made the 5-day journey to Colorado. When they arrived, they could not speak English, were in culture shock, and only had what they had packed in their van. Today, Carlos volunteers at Centro San Juan Diego as part of the Our Court program, teaching citizenship classes to Spanish-speaking immigrants, just like the classes he and his family took when they became citizens. Before joining the court, Carlos was a district court judge in Arapahoe County, where he presided over the Aurora Theater shooting trial. Finally, Justice Maria Birkenkotter. Justice Birkenkotter is our newest member of the court. As my first official act as Chief Justice, I had the pleasure of swearing Maria in on January 4th. She's a former trial court judge and chief judge in the 20th Judicial District, which is Boulder. She has spent years working with stakeholders to develop innovative programs that address public safety, mental health, and substance abuse issues, as well as to improve court operations. Maria has 2 daughters who are also interested in the law. One was sworn into the bar in the fall of 2019, and one will start law school this fall. At the risk of appearing selfish, I'd like to also tell you who I am, since I've given you my personal commitment to lead this culture change. I'm a Colorado native. I grew up in the Wheat Ridge Edgewater area, and I am a proud Jefferson Saint. I decided I wanted to be a lawyer when I was 5 years old after my dad, who was a lawyer, took me to work one day. He took me to an adoption, and I remember that he made these 2 people so happy, I thought he was like Santa Claus. After that, I never thought about anything else but being a lawyer, just like my dad. Flash forward 25 years or so, and I'm in court trying a case. At one particular hearing, the judge treated me very badly, very intemperately. And I remember thinking that even if the judge was right on the law, there had to be a better way of communicating. That was the first day I thought about becoming a judge. A few years later, I had another experience that cemented that desire. I prosecuted a murder case that dragged on for about 2 years due to the defendant's significant mental health problems. Ultimately, the jury convicted the defendant of first-degree murder. As a result, the only sentencing option available to the judge was life in prison. I should note this took place before the Victims' Rights Act was enacted. When I asked the judge if the victim's family could speak prior to sentencing, the judge, who happened to be an excellent judge, unfortunately denied the request, announcing the court did not have any discretion regarding the sentencing. I will never forget the faces of the victim's family that day. That day, I decided I was going to become a judge, and I promised myself that if that ever happened, I would do everything in my power to let people know I cared and truly listened. A few years later, I was appointed to the district court in Jefferson County. That was 22 years ago. And treating everyone with dignity and respect to the very best of my ability has been the cornerstone of my judicial philosophy. And becoming Chief Justice didn't change that. That's why I'm serious about getting answers here, because at heart, all of this is about how people are treated. Approximately 18 months ago, our court realized that we had significant issues within the department that required immediate action. While the culture problems were not caused by any specific individual, and I'm not blaming anyone, we concluded that change was necessary. As a result, since that time, almost the entire SEO leadership has been replaced. First, Stephen Vasconcelos became the new state court administrator. While Stephen was with SCAO, we selected him from a national search. During that process, we engaged all members of the branch and solicited their thoughts on the finalists' vision statements, as well as their thoughts after in-person and virtual town hall appearances. We made every attempt to run a transparent process. Since that time, we've also hired a new director of finance, a new director of court services, and we're in the ongoing process of hiring a new director of human services. Next, our court changed how we handled administrative responsibilities. Traditionally, the chief handled all of the administrative responsibilities, and the rest of the court received reports on various actions. While the goal of insulating the majority of the court from matters on which it might ultimately have to render a decision was laudable, it was not workable. We realized that we all needed to be much more involved in the branch. We were too disconnected from the employees. As a result, we decided to assign justices to the different departments or functions within the branch. Justice Marcus is assigned to the clerks of court, Justice Hood to financial, Justice Gabriel to IT, Justice Hart to court executives, and Justice Samore to human resources. We're going to allow Justice Birkencotter to get her legs under her before we give her an assignment. At that time, I remained the liaison to probation. We implemented this system not only to improve the flow of information, but to also helpfully develop relationships with the employees of the branch. We realized that important information was not getting to the Chief Justice or the court. If information needed to reach leadership, we wanted our people to feel comfortable approaching us and talking with us. In addition, we instituted rotational terms for our Chief Justice. Justice Marcus will be the next Chief Justice. We did this in part to keep fresh eyes on things. We now embrace the philosophy that 7 brains are better than 1 and 14 ears are better than 2. There is a real benefit in relying on the collective wisdom and experience of all 7 justices in running the branch. I would be remiss if I didn't recognize another crisis around how our minority communities perceive their treatment in the criminal justice system. To that end, we've stepped up our efforts to help diversify the bench. We feel this is an important part of enacting real, lasting change. One of the best ways to ensure equal justice for all is to have judges that reflect the communities they serve. To that end, 5 years ago, several of our justices formed a bench diversity dream team through Colorado Center for Legal Inclusiveness. The bench dream team became a vehicle to encourage diverse lawyers to consider a career on the bench and help them navigate the judicial application process. Bench Dream Team members have volunteered countless hours hosting informational sessions and meeting with potential applicants and conducting mock interviews. As part of the Dream Team effort, Justice Marquez teamed with the Center for Legal Inclusiveness, the Diverse Bar Association, judges, nominating commission members, and 9 News alum Adele Arakawa to produce a training video for new nominating commission members. Among other things, the video teaches commissioners how to combat implicit bias. Retired Judge Gary Jackson, through his tireless work, made diversifying the bench an urgent priority. Representative Leslie Herod suggested that we hire a judicial outreach coordinator who would help identify and recruit diverse candidates to the bench. Because of the hard work of the bench dream team, Judge Jackson, Representative Herod, Sumi Lee, our outreach coordinator, Patty Jarzobski, and many, many others, we have made some inroads. I'm proud to say that Governor Polis appointed more black women to the bench, 5, in the 1-year period between September 1st, 2019 and August 31st, 2020, than in the previous 25 years combined. In addition, 59% of the judges appointed by Governor Polis in that same time period were female. That's resulted in a nearly 13% increase in female judges in the last 4 years. With that said, the protests for racial justice that took place this past summer and more recent events remind us that much more work remains to be done. Those events have led us to significantly increase our training around issues of racial equality. Judges Paul Dunkelman and Adam Espinoza, through their leadership roles as presidents of the District Court and County Court Judges Associations, respectively, have put on a continuing series of excellent webinars on these issues. That webinars are extremely well attended by judges across the state, and in addition to several districts have made discussing racial justice a special priority. I want to acknowledge the work of the Court of Appeals, for example. That court established an inclusivity, diversity, equity, and anti-racism committee to combat systematic racism and injustice by promoting acceptance, respect, and value for all persons and creating an ongoing dialogue to confront biases. To date, the Commission has undertaken a number of projects, including spearheading amendments to the Court of Appeals Strategic Plan regarding diversity and inclusion, compiling and sharing resources about the DEI trainings, and facilitating discussions inside and outside the court, including with regional law schools and law students on these issues. In the vein of openness, we've also looked at the court's practices around sealing records. This past December, with the able assistance of our Colorado Criminal Rules Committee, the court enacted Rule 55.1 to those rules. Rule 55.1 is a rule of transparency and accessibility. To borrow from Justice Louis Brandeis, by allowing better and more expedient access to court records, the new rule recognizes sunlight as the best disinfectant. Once the rule takes effect this May, a trial court will not be permitted to limit the public's access to any part of a court record in a criminal case unless the judge makes written findings that 1, a substantial interest would be served by making the court record or any part of it inaccessible to the public. 2, There's no less restrictive means than making the court record or part of it inaccessible to the public in order to achieve or protect that substantial interest identified. And 3, substantial interest identified overrides the presumptive public access to the entire record. Additionally, any order limiting public access to court record or any part of it must indicate a date or an event certain which the order will expire. This will ensure that orders limiting public access do not linger unnecessarily. I bring these changes up not to claim that we've already changed the branch culture, but only to demonstrate that we are committed to the continued reflection on how we can improve. It will take time, but we are committed to the cause. I started my speech by recognizing that we as a branch are in crisis, but we also face another crisis. This, however, is not a crisis of our own doing. This is a practical crisis caused by the pandemic. To be clear, our trial courts and probation officers have borne the brunt of the effects of the pandemic. Despite risks to their health, our trial courts and probation departments have remained open for business at all times during the pandemic. Our people have acted with the courage of first responders by doing the work required. In my opinion, they've been heroic. While we've made significant changes to how we do business by virtual and telephonic hearings when possible, there are some hearings that simply require in-person proceedings. Our chief judges have been amazing in how they've innovated and how they've modified courtrooms to allow hearings that must be held in person to be as safe as possible. But then there are the jury trials. They just have not been possible for much of the past 12 months for safety reasons. As a result, we face an unprecedented backlog of jury trials. And I'll give you a few numbers that demonstrate our plight. Over the past 5 years, we've held an average of 2,716 jury trials a year. That's on average, with 2,400 of those being criminal trials. On January 19th of 2021, we had 14,635 jury trials scheduled statewide, with over 10,000 of those being criminal trials. What that means is we have somewhere between 4 and 5 times the number of criminal jury trials scheduled than we try in an average year. And crime has not stopped. Serious crime has not stopped. We come to you asking for help. But before I address what our strategy is to confront this unprecedented challenge, I want to share with you my greatest fear about what I'm asking. I recognize that many of you are angry at the branch for the unwanted attention that it's brought to government, and you have every right to feel a myriad of different emotions about that situation. My plea is that you don't take your anger out on our trial courts and probation, because that is about serving the people of this state. So I ask you, if you're going to be mad at me. Our trial courts need help to provide access to justice that our citizens need and deserve. Without assistance from the General Assembly and ultimately the governor, will not be able to adequately address the tsunami of jury trials that await. I've had discussions with some of you about one of the biggest challenges enforcing the defendant's statutory right to trial within 6 months of entering a plea of not guilty. In the early stages of the pandemic, with the assistance of the Criminal Rules Committee, we were proactive in this front and adopted amendments to Rule 24 of our Rules of Criminal Procedure. This amendment provides us some flexibility while we're in survival mode. Rule 24, however, only applies as long as a fair jury pool cannot safely be assembled. Therefore, once our trial courts are able to summon jurors with some semblance of normalcy, we'll face significant challenges in this area. We're going to have thousands of trials with either 90-day or 6-month deadlines. We need your help. We're asking for 3 things. One, we're asking that you revise the senior judge program to create flexibility that will allow more of our most experienced jurists to either preside over jury trials or to free up our currently sitting judges to try more jury trials. We have recently retired judges who are willing and able to step in but do not want to commit to the required 60 or 90-day contract that's currently required by the statute. We need more options for length of service. We also need additional money to expand the program. We have good judges on the waiting list hoping to help. Two, we're asking for additional staff and magistrates. As you may be aware, when the governor asked for budget reductions last spring, we complied. After significant soul searching, we eliminated nearly 200 positions, which required laying off 110 people from every part of the branch. With the exception of one position, we're only asking for staff to help the trial courts and probation. Jury trials require staff, and conducting jury trials safely during and after a pandemic requires more staff. Three, we're asking you to allow us some flexibility around the 6-month statutory deadline. As I mentioned, the amendments to Rule 24 will no longer be effective once jury trials resume in earnest. Just knowing that jury trials can be held will encourage resolution. Recently, I had a meeting with many of my partners in the criminal justice system. This included 2 chief judges, the Attorney General, the Public Defender, the Director of the Office of Alternate Defense Counsel, the head of the Colorado District Attorney's Council, several DAs, and others. It was a productive meeting, and we discussed developing a best practice template for triaging the backload of cases. I welcome working with these same partners around a reasonable amendment to the 6-month statutory deadline for criminal trials. As I speak to you today, jury trials are slowly resuming in some of the judicial districts, with others to follow in the coming months. I'm continuing the practice started by my predecessor, Chief Justice Coates, of empowering our chief judges in each district to decide how and when to resume jury trials. Despite criticism to the contrary, one size does not fit all in how individual courts are run. For example, what works in Greeley may not work in Montrose, and vice versa. That's because we have different positivity rates in different counties, coupled with different courthouses, with different facilities, and different technological capabilities. The decision of how and when to resume jury trials has to be made on the local level. The chief judges are working extremely hard, and they all have a common goal: to resume jury trials as soon as they can be done safely. But even then, the trials will start slowly due to safety protocols. We want our jurors safe when they serve. The pandemic has also brought some positive changes to the practices of the court and the probation departments, and I fully expect that many of these new practices will continue into the future. As just one example of many, parents in the dependency and neglect cases have difficulty traveling to and from court due to a lack of dependable transportation. We have seen that many of these review hearings in these cases, which can be brief if things are going well, can be handled remotely, thus helping parents avoid missing work or treatment. And this practice will be employed across all case types as appropriate. The pandemic complicated work for our probation departments in particular, because establishing the relationship between a probation officer and their clients is frequently the key to successfully completing probation. I'm sure everyone in this room has experienced the difficulties of connecting with various people via one of the virtual platforms. With that said, our probation officers have made necessary adjustments and have remained committed to helping their clients and providing services to the best of their ability. When people talk about the work of the judicial branch, they often overlook probation. But I want to remind everyone that probation remains the most cost-effective method for supervising offenders. This fiscal year, an offender incarcerated in the Department of Corrections will cost the state approximately $46,866. An offender in the Community Corrections Program, approximately $9,936. And an offender on parole, approximately $6,924. An offender on probation, by contrast, will cost the state $1,662, a fraction of the cost of any of the alternatives. I also recognize that some people are under the impression that probation operates as a sort of zero-tolerance punitive system. That if, for example, an offender on probation misses an appointment with his probation officer, the officer will immediately file a motion to revoke. That's just not accurate. To the contrary, probation focuses on providing offenders with the rehabilitation and support they need to regain control of their lives and contribute meaningfully to society. I want to share a story of one probationer. Her story is not an outlier, and I'm going to share her story in her own words. When I started probation, I came as a broken soul. When I came to my first appointment, my children and I were bouncing between living in my truck and a house filled with multiple dealers. We struggled with basic necessities like finding a restroom and getting water. After a few months of failing on regular probation miserably, I was handed off to a new program, Specialized Drug Offender Program. I sat in orientation and they discussed the program and the treatment provider, Mile High Behavioral Health Care. They identified so many resources, expressed an underlying faith in all of us as addicts and our ability to recover, and provided support from all angles. I left the room with tears in my eyes. This is what I needed. I started treatment and I saw my probation officers weekly. Treatment became my family, probation officers my mentors. They helped me instill faith in myself again. They believed in me and truly cared about my children and me. Today I'm a peer coach. My future is limitless. Her probation officer reported that this client was granted early termination and has carried forward what she's learned in her new life. This is emblematic of the work of probation officers across the state. I know from my time as a trial judge that probation officers take great pride in their client's success and consider it a personal defeat when their clients fail. I am proud to have such dedicated people as part of the branch. Although I gave you a brief summary of who I am a few minutes ago, I neglected to mention that in my limited free time that I have as a justice, I also enjoy reading history, even if that means listening to a book on tape during my commute. I'm particularly fond of Abraham Lincoln for his strength of character, grace under pressure, and communication skills. If you visit my office or home, you'll notice multiple books on Lincoln, including one about his time riding the circuit in Illinois as a young lawyer. As he so often did, he wrote something that is still applicable today. In his second annual message to Congress, delivered on December 2nd, 1862, after one of the costliest battles of the early Civil War, when he feared the Union's resolve to win the war was waning, Lincoln stated, and the words have meaning to me today, "The dogmas of the quiet past are inadequate to the stormy present. The occasion is piled high with difficulty, and we must rise to the occasion. As our case is new, so must we think anew and act anew." Lincoln was talking about the survival of the country. I'm talking about maintaining the independence and integrity of the judicial branch. So I echo his words today. We will think anew, and we will act anew. I want to assure you that we, the judicial branch, will bring that same clear-eyed perspective, energy, and determination to tackling the challenges that face the branch and the administrative justice in Colorado during these trying times. We are committed to lifting the clouds over the branch and making it once again a rightful point of pride. I look at all of you in the eye, and I commit to you, I promise to you, we will get this right. Thank you for the privilege of addressing you today. I promise I'm not milking the applause. I'm trying to get my mask on.
Thank you, Chief Justice Boatwright. Will the committee please escort the Chief Justice from the chamber? Madam Majority Leader.
Thank you, Mr. President. I move the message from the Chief Justice be printed in the House Journal.
Seeing no objection, the Chief Justice message will be printed in the House Journal. Mr. Majority Leader.
Thank you, Mr. President. I move the joint session be dissolved.
Seeing no objection to the Majority Leader's motion, the joint session will be dissolved.